Circumstances in which non-owner of goods could do what? Could sell them and pass good title. Now, candidates, have you heard something known as sale by mercantile agent? Sale by mercantile. Mercantile is derived from the word merchandise. Okay, sale by mercantile agent. A mercantile agent, candidates, is someone who has possession of goods or documents of title of goods with the owner's consent. Okay, and acts in the ordinary course of business as a mercantile agent. You understand? A mercantile agent, first of all, is an agent, and is an agent of goods, because you have different kinds of agents. Okay? You understand? There are different types of agents. There is one we are calling mercantile agent. And I'm defining a mercantile agent as one who is in possession of goods or title to goods. It could be goods or title to goods. And the agent has ownership of this or possession of these goods with the owner's consent and acts in the ordinary course of business as a mercantile agent. So that is one circumstance. You understand? So the goods do not belong to the agent, but he can still pass title. He can still sell the goods and pass good title, though the goods do not belong to him or her. You understand? So the buyer here acquires good title of the goods, even though the seller, who is the agent, did not own them. Have you understood? If you have, please give me go ahead to proceed. A mercantile agent is one who is holding goods for another person, so he is allowed to sell the goods even if the goods do not belong to him. Another circumstance is sale by a voidable title. Sale by a voidable title. Sale by a voidable title. Sale by or under. Sale under a voidable title. Sale under a voidable title. Let me be specific. Sale under a voidable title. 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 I've repeated it 7 times and I've done it deliberately. We learn through repetition. Okay? The problem with adults, when you tell them, repeat before me, sell under a voidable title. They don't take you serious. They think you think they are children. But it helps. Wherever you are, you can say it. When you say it, it's another way of reinforcing so that you can remember. Sell under a voidable title. What does that mean? Voidable title. Now, candidates, a person with a voidable title, an example of a voidable title is having goods fraudulently. Okay, from the word void. Okay, a person with a voidable title, for example, obtained through fraud or misrepresentation, can pass a good title to a buyer or purchaser for value before the original owner resigns the contract. You understand, candidates? We are discussing circumstances in which a non-owner of goods could sell them and pass good title. One such circumstance is sale under a voidable title, for example, where someone obtains a title through fraud or goods through fraud or misrepresentation. A person who obtains goods or title to goods through fraud or misrepresentation can still sell them and pass good title. You understand? Have you understood? Sell under voidable title. And candidates, that means that the buyer acquires good title. Okay, the buyer acquires good title to the goods, even though the seller's title was originally defective. So that means, candidates, someone can sell you goods as a buyer. You have good title to the goods, even though that person obtained the title fraudulently. You understand? But of course, there are conditions. I don't want to get into conditions. The question did not ask about conditions. This does not just happen. There are also conditions that make the title moved, that enables the sale to have good title. There are conditions which you may also be asked. The topic is sale of goods. The third circumstance in which non-owner of goods could sell them and pass good title. The third circumstance. We've said the first circumstance is sale by mercantile agent. The second one is sale under voidable title. The third one is sale by a seller in possession after sale. 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 Sale by a seller. Sale by a seller in possession after sale. What does that mean? That means, candidates, that if a seller remains in possession of goods after selling them and then sells them again to another purchaser for value, the second buyer acquires good title. Sale by a seller in possession after sale. If a seller has sold goods to buyer A, okay, a seller sells goods to buyer A. This buyer A buys goods, but these goods remain in the possession of the seller. This seller can, because after selling the goods to a seller, candidates, once the buyer has paid for the goods, then the seller is no longer the owner of the goods. But the goods that have been sold to buyer A can be in the possession of the seller. So if you have bought goods from the seller and you have not picked the goods are in the possession of the seller, but the goods do not belong to the seller. Maybe you delayed to come and pick the goods. This seller can sell these goods to buyer B. The seller can sell again the goods to buyer B. And the goods that he's selling to buyer B, these goods are not owned by this seller because he already sold them to buyer A. That's what we are saying. Sell by a seller in possession. Sell by a seller in possession after sale. Okay, he sold the goods. The ownership was transferred to buyer A, but the seller maintained the possession of the goods. So these goods can be sold to buyer B, and that is allowed. Okay? Pass good title. The title to the goods is passed to buyer B. You understand? You understand, candidates? The second buyer, in other words, acquires good title, even though the seller no longer owned the goods. This seller, when selling the goods to buyer B, he no longer owned these goods. But the buyer, candidates, the second buyer acquires good title. Have you understood? Is that clear? All right. Let's move on to the fourth circumstance. The fourth circumstance. This one is related to the buyer. Sell by a buyer in possession. Sell by a buyer in possession before sale. 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 That is to say, if a buyer obtains possession of goods with the seller's consent before the sale is complete and then sells them to another buyer the second buyer acquires good title. Sale by a buyer in possession. So here, candidates, this is what we mean. We have sale by a buyer. So initially, the seller sold the goods to buyer A. The goods were initially sold to buyer A. Before the sale was complete, maybe, for example, the buyer had not paid the goods. Because before the buyer pays the goods, ownership is not transferred. So seller can sell goods to buyer A and he passes the possession. So the goods are in the possession of this buyer. But the sale is not complete. He is not paid for the goods. But the buyer has possession of the goods. And given that the buyer has possession of the goods, he can sell these goods even though he does not own the goods. Non-ownership, does not own the goods. Does not own the goods but sells to buyer B. That's what we mean by sale by a buyer in possession before sale, before the sale is complete. So these are just legal language, candidates. You can put it in your own words. You can say where a buyer buys goods. You can use simple language, normal English, and still earn the marks. That's why I'm asking you if you have understood. And if you have understood, you can write in words that you will remember. You understand? But since we are studying law, we need to use legal terms. You can say where a buyer buys goods from a seller but does not complete the sale, the buyer can sell the same goods that he has not completed the sale to another buyer. You understand? So the second buyer, candidates, acquires good title. The second buyer acquires good title, even though the first buyer did not own the goods. You understand? Have you understood? Now, these are candidates' provision of the Sale Goods Act. Sales of Goods Act. And candidates, the underlying principle in all these situations, if you've been keen, the reason for this law, this is law. This is what the law states. So if you buy goods from a buyer who does not have ownership, you are protected by the law. This seller cannot come and claim the goods from you. You are protected by this law. So the underlying principle in all these situations, in all these circumstances, is to protect innocent buyers who act in good faith and without any notice of any defects in the seller's title. Okay? That is to promote trade. You can imagine when people are selling, when you go to the market to buy goods, you've gone to the market to buy a tie, like the way I went to buy this one. Okay? The law protects me, even if the tie was stolen, or if the one who sold to me had bought it on credit and had not cleared. Okay, so the original owner of the tie cannot come and claim it. So the underlying principle, the reason why we have this in law is to protect innocent buyers. The law here, candidates, aims to facilitate commerce by ensuring that buyers can rely on what we call apparent ownership or authority of a seller, even if they are not the true owners. You understand? And as you study this subject, candidates understand the reason why we have laws. There is a reason why we have such laws. The law does not just exist for the sake of it. We have a law. The purpose of this law or these circumstances, the underlying principle is to protect buyers, is to protect innocent buyers, not just buyers, but innocent buyers.